today by Matthew Cole.
Hello.
And today we're talking about redundancy and restructuring. So what we have done for you with regards to the slides is quite a full slide pack, especially for those of you who may be new to the area of carrying out redundancy processes. So hopefully it's a good reference point for you to go back to if you find yourselves in a situation where you have to carry out a redundancy process, because it kind of outlines the different stages that you need to think about. However, what we would like to do today actually is kind of discuss some more of the nitty-gritty areas in respect of some of those items listed under the introduction slide there. For example, I'm going to talk a little bit about trial periods, which actually I find when advising clients kind of get skipped over occasionally. And statutory trial periods are mandatory when they apply, so it's good to know it and be aware of them. So we're going to talk about what is a genuine redundancy situation. We're going to talk about consultation. We're going to talk about selection, or I'm saying Matthew is going to talk about the selection process, both in terms of looking at the selection pool and then, of course, the selection criteria. I'm going to talk about alternative employment and trial periods, as I've just mentioned. And we're also going to chat about redundancy pay, entitlement to pay, and when perhaps an employee is not entitled to the pay. And also conclude with actually, are there any alternatives to redundancy? Because we all know that actually carrying out a redundancy process, especially when there's a number of employees affected, can really kind of impact on a company's morale with their staff. So that is essentially what we want to cover. It's quite a list. Redundancy is a big topic, but as I say, we'll probably focus on those kind of nitty-gritty areas. We've got some kind of life examples on.
Fair to say one of the topics we probably advise most on.
Yes, actually. Absolutely.
And also
yes.
One of the longest in the tooth. You know, we've had redundancy around since the 60s in terms of law. So plenty of law to cover as well.
Lots of case law to cover. Yeah. So redundancy situations. So now I'm kind of thinking about, all right, okay, when would you, you know, as an HR director or another director, kind of think, or even HR, think, okay, there's a situation here. Is it potentially a redundancy situation? Well, this could be, you know, economic pressures requiring reduction in staff, and by this I kind of meaning when you identify that there's a need to cut costs, and one of those is obviously looking at your staff base. For example, there might be a change to a business. We might change the nature of products or the services that we provide, and therefore we need a different skill set in our staff, which may lead to a redundancy situation. We might find ourselves in an unfortunate situation where we have to decide to close a business, and I think that's the most obvious example of a redundancy situation. We also have others, such as relocating the business, the needs for internal reorganisation, and that's when we will start to think a little bit later on, are we restructuring or is there a redundancy situation? How do those two fit together? And also finally the technological development, which might result in a change to job functions, and again we might think, oh, is this a redundancy situation?
There's quite a lot of stigma around the word, isn't there?
Really? There is,
and
yeah.
I think what we find is that it's got this technical legal meaning, and clearly it is a word which can strike fear into the hearts of workforces and affect morale. But actually there are also some very positive reasons why, from a legal perspective, you may be using redundancy as a reason to change the workforce.
Absolutely. So we do need to just briefly look at the definition of redundancy. And that will always be our starting point whenever we think you have to carry out a process, is that actually does the statutory definition of redundancy apply? And it's important for two reasons. First, and I suppose the most obvious reason, is that it's potentially a fair reason for dismissal, so you want to make sure that it fits within that box. And secondly, of course, is that if it isn't a genuine redundancy situation, then the employee wouldn't be entitled to statutory redundancy pay. So the statutory definition of redundancy is set out there on the slide, and I will let you read it, but essentially we summarise it by either having a business closure, a workplace closure, or a reduced requirement for employees. We have the Safeway stores antiviral test, which is quite a simple test that tribunals always ask themselves and go through whenever we're looking at redundancy. And that is, first, was the employee dismissed? And if so, we move to the second stage, where they ask, have the requirements of the business for the employees to carry out work of a particular kind ceased or diminished? Or if not, was there a business closure or workplace closure? And that's obviously looking at the definitions there. And if so, the final question they ask is, was the dismissal of the employee caused wholly or mainly by either the business closure or the workplace closure or the reduced requirement for employees? And that's a useful test to be aware of and remind ourselves of when we go through the process.
Fair to say, over the years, there's been a lot of case law around what is actually a basic question, and all the time the courts are bringing it back to the fact that it's a basic question. They will effectively say, well, if it looks like a redundancy, then it is a redundancy. Has the business got a reduced requirement for workers one way or another?
And I must also say, it's also true that tribunals don't, they don't go to, if they're satisfied that test has been met, then they don't really go to drill down into the business reasons behind it.
Absolutely,
and I think some clients get quite concerned about that, they trust, the business in terms of, business decisions need to be made.
It's a good point actually to note when you're talking about consultation as well, isn't it? You'll often have individuals who are coming to you sort of very much wanting to say that the business decision is wrong, and therefore that makes their dismissal unfair. And the tribunals just do not look at it. Do not look at it like that.
That's the good news.
Yes.
But I'm now, after the good news, going to look at just a few examples of difficulties with each of those definitions, or the different strands of the definitions of redundancy. Business closure, I think this covers, it's business cessation in a way. So it covers both permanent closures and also temporary cessations of business, which I think is quite an important point to note. So, for example, a business might close for an extensive refurbishment, or perhaps financial circumstances, it closes and then a few months later it reopens again when it comes into new finances. So if there is a temporary cessation, that can still be a redundancy situation. We do have to be a little bit careful with that one because, and there is some case law around this, but for example, tribunal found that a 4-week closure just to refurb a business wasn't a temporary cessation. But that's quite an interesting point to be aware of. If we have a business closure because we want to change the business, then there the tribunal will look very much at what the business was like before the closure and what it's like after the closure. If they feel that it's very, very similar, then they'll find that there wasn't actually, in fact, a business closure meeting that definition.
It's very common with pubs and restaurants and things like that, where they want to rebrand or refurb. We see that quite commonly.
We do.
Different
in
ways
retail.
Absolutely, in retail as well. Different ways of looking at how you might actually just keep the workforce on board without making them redundant during those periods. It's always worth consideration.
Yep, and that's also actually where our last slide might become useful as well, alternatives to redundancy. And the only other point I was going to make on business closures, which I'm sure you all know, is obviously if there is a transfer of the business to a new employer, then that's actually a cheapy situation, potentially, rather than redundancy. Just wanted to make that point. Workplace closures. The employee's place of work for redundancy situations, you need to look at the circumstances immediately before the dismissal, i.e. where did the employee work? You don't just look at the employment contract, which is an important point because some employment contracts are quite old. An employee might move around.
We were talking about the Safeway and Burrell case, and one of the big issues in that case and in a lot of these cases is, do you look at the contract test and what the employee can be required to do, or do you look at what they're actually doing? What Safeway and Burrell effectively says is you just put everything into the mix, and then you form a view as to whether or not the employee's work of a particular kind has ceased or diminished. It is a question of fact.
Yeah, absolutely. And I think the only other point I'll probably make with workplace closures is mobility clauses, because of course many contracts, especially now, and the ones that we help clients put together, say that your place of work might be here, or you may be required to work in another office. And of course, if you do have that mobility clause, are you looking at actually invoking that clause, or are you looking at redundancy situations? So that's just something also to be aware of, and that's when it is important to look at the contract.
Can I just draw a point out here? I think we're talking about whether or not a redundancy situation exists in these cases. And one of the things I've always found is that there can be arguments either from the employee or the employer as to whether a redundancy situation exists. You can have a situation where the employer is saying, no, this is a redundancy, because the employer's eye is very much upon potentially fair reasons for dismissal and making sure the dismissal is going to be able to stack up at a tribunal. Other times you'll have the employer say, no, it's not a redundancy. It is just a closure of this particular restaurant, but we've got other jobs. And the employee saying, no, you're making me redundant.
Especially with 20 years service.
Absolutely,
of course they will.
because they've got an eye on the redundancy pay.
Yeah.
So it can often be a battleground either way in terms of whether or not you're arguing redundancy. There is, however, a presumption in law that if you dismiss an employee, then the presumption is you've dismissed them by reason of redundancy for the purposes of redundancy pay. So we just need to bear that in mind as well. But it can be a real battlefield.
Yeah, it can, and we've seen it many times.
Yeah.
Sorry, could we just skip back so I can finish off on reduced requirement for employees to do work of a particular kind? This is discussed quite a lot with our clients. The classic examples of this is, you've got less work, so you need less employees, or you might actually have the same amount of work, but you need less employees to do it. And that's obviously where you're kind of consolidating roles. But I think where we sometimes have, another example would be less. Yes, so for example, that would have been job function. Sorry, I'm losing myself now. Another example, which I just did want to talk about, is sometimes I have clients phone me up and want to talk about the whole issue of, well, actually we've got part-time workers doing the role, but we want full-time workers doing the role. Is this a redundancy situation? And that's quite a tricky one, because actually we're still quite unclear with case law whether part-time work can actually be work of a particular kind to meet the definition. And of course you have to go back to the question, is there a reduced requirement for employees to do work of a particular kind? And if the work levels are the same, there isn't actually a reduced requirement for employees to do that work. So perhaps unlikely to be a redundancy situation, but it is something that will be quite specific in some ways. And
of course, hot water around part-time discrimination issues as students are there as well.
Yes, indeed. That opens up a whole different can of worms, doesn't it? And then finally, I've just put on there the question of, well, actually, do we need to kind of carry out a reorganisation or a redundancy exercise if we're unsure of the answers of any of the questions that we've raised? And for that, I'm going to pass over to you.
It's very nice. Neatly into the next slide, Vanessa. Thank you. Which is, if we go back to what we're looking at employment law, we're looking at unfair dismissal law in particular. We've looked at redundancy as being the potentially fair reason for dismissal, and as I said, there's a presumption there. But what happens if we do want to dismiss an employee, but we don't feel we've necessarily got a redundancy? Well, this is where we rely upon something which you may have seen, you may have heard about, which is SOSR, some other substantial reason, as a potentially fair reason for dismissal, or SOSR as we know it. And effectively, it's a catch-all category where you're saying, well, it's not one of the other potentially fair reasons, it's not conduct, it's not capability, it's not redundancy, but we still have a good sound business reason for terminating the employee's employment. And you'll see there the definition, very wide. It's some other substantial reason of the kind to justify the dismissal of an employee holding the position which the employee held. And it's often referred to, and we will often, if we're fighting an unfair dismissal claim on behalf of an employer who has made some employees redundant, then we will often say, well, it was redundancy, but even if there wasn't that potentially fair reason, then there was still some other substantial reason which justified the dismissal of the employee. So even if you are struggling to get your restructuring into a redundancy situation, you can still rely upon the potentially fair reason, may even save yourself some money on the redundancy payments as well. What kind of things are we looking at with some other substantial reason? Restructuring short of redundancy, technological changes. You might find that you still need the same number of employees doing the same job, but in a different way. So you still got the same bums on seats, or the same number of bums on seats, but they're different bums. That's where we may find we're looking at a restructuring. Also, changing terms and conditions. Let's say you've got a workforce who are on outdated terms and conditions, or a shift pattern, for example, which no longer works. Again, SOSR may justify that dismissal, even though there's not a redundancy situation. Or we may just find that there are requirements for new qualifications or competencies for a job. It happened in the financial services market about 3 years ago now, where the level of qualification which various advisors needed increased significantly. Not all of them could get those qualifications, and therefore you were looking at restructuring the workforce, reorganising that workforce, but not a redundancy situation. So again, dear old SOZA comes into play. It's just worth looking now. I will go back to the previous slide, but I just wanted to look at this one first. That when we are looking at advising on dismissals, when you're looking at your redundancy exercise and you're looking at how you do it fairly, really just bear in mind this two-stage test. Have we got a potentially fair reason? And the ones we're looking at here are redundancy or SOZA. We then go on to ask ourselves, did the employer act reasonably or unreasonably? Or rather, this is a question the tribunal will ask. Did the employer act reasonably or unreasonably, taking into account whether in the circumstances, including the size and administrative resources of the employer, there was sufficient reason to dismiss the employee? Size and administrative resources is important. More will be expected of a large employer normally won't it than a smaller employer. But that's only one of the factors. And we'll see here, and it's one of the beauties and also the problems of employment law, unfair dismissal law in particular, in that we've got this wonderfully vague test of reasonableness, which hides a multitude of sins. It's a judgment for the tribunal to apply. It's actually on one level quite an easy test for an employer to meet, because the test is looked at by the tribunal from the employer's perspective. Did the employer act reasonably, knowing what that employer knew at the time? Did they act within the range of reasonable responses? The tribunal isn't saying we would have done exactly the same thing. They're asking whether or not the decision was reasonable. So it's a vague test, but at the same time quite a useful test. And when we're looking at applying that to unfair to redundancies, we're really looking at how that then plays out. It's a very established area of the law. How that plays out, what are the principles behind that we can extrapolate from the cases? There's a number of things which are on the slide there where it's worthwhile bearing in mind, but I'm going to bring it back to what I see as the Holy Trinity whenever you're looking at redundancy. You're looking at selection, consultation, consideration of alternative employment. Always those three things. That's always what we're asking the client when they're looking at a redundancy situation. What have you done with regards to selection? Have you consulted? Have you considered alternative employment? That's one of the things which will just inform us as we go forward. And there they are. They came about in the Polti case. Many of you will have heard of Polti. It's a case which is always now an issue in any kind of unfair dismissal case, and it's a defence of last resort to a certain extent, isn't it? Because what you're saying is, even if we were unfair, even if we acted unfairly, we still would have dismissed, and therefore compensation should be zero. And that's known as the Polti chance or the Polti deduction. What Polti actually established was the principle. It was a case where it involved redundancy, and it involved a procedural defect in the process. And what it established was that if there is a procedural defect, which the employer can show would have made no difference, you still have an unfair dismissal because procedure is so central to the reasonableness of that dismissal. But it comes out in compensation. As I said, it leads to that Polti reduction being applied. So you've got to try to get your procedure right. There may be cases where you play fast and loose in it, but you can always plead Polti to say, even if we'd done everything properly, you still would have been dismissed. We still would have come to the same decision. So that's Polti in a nutshell. And as I said, back to the Holy Trinity: consultation, consideration of alternatives, selection. I'm going to start with consultation.
Yes, we're going to start with consultation. Looking at the key components of consultation, which is being determined by the British Coal case up there on the slide. So what are the key components? Well, in a nutshell, need to consult when the proposals are still at the formative stage. I do not come across as if you have made all the decisions and it's a slam dunk, the employee is redundant. So consult when they're at the formative stage. Give adequate information to the employees so they can respond to it. Give them adequate time in which to respond, and that comes to the, how quick is the process and how short are the meeting, how quick are the meetings fit together. And also, of course, do a look as if you are carefully considering the responses that the employee gives to you and the points that they raise, rather than not going back to them or answering their questions or looking as if you're not paying attention at all to what they're trying to say to you. So that's the consultation requirements in a nutshell. What we just need to be aware of is just where we have redundancies where there's less than 20 employees at risk of redundancy, which we've kind of termed small scale redundancies. You may not consider them to be small scale if you've got 19 employees, but still. But what we do have to be aware of is potential collective consultation for large scale redundancies. And so we've set out the test as it were there, but employers proposing to dismiss as redundant 20 or more employees at one establishment within a 90-day period, they must engage in collective consultation with a trade union, or if there's no trade union, recognised elected employee representatives. What I don't propose to do today is go into detail with regards to what is one establishment, because I think there's a raft of cases on there that's quite constantly moving in the case law, isn't it?
Yeah.
And I think that'll probably take up a good chunk of a separate webinar.
Should we say now, though, for one establishment is normally one office, one shop, one restaurant, one workplace, one factory, etc.
Yeah.
Just while we're on definitions, can I just make another point about this?
Yeah.
Which is that what we mean by dismiss as redundant?
Yes. Good. No, you carry on.
Yeah, you sure?
Yep. Okay. Just in case you're going to say something different to what I was going to say.
That for this purpose, for the purpose of complying with the collective redundancy consultation obligations, redundancy has a wider meaning than what we were already talking about, and will cover many of those other restructuring situations. So, for example, if you're looking at dismissing employees to change shift patterns, for example, for this purpose, consultation only, we're in a redundancy situation. It's a much wider decision because it comes definition because it comes from Europe, and even after Brexit, whenever we finally end up leaving, we will still have that wider definition.
Yeah.
Any no-fault dismissal, is that a good way of putting it?
Yeah.
Whenever you're looking at a no-fault dismissal, you need to be considering whether you've got 20 or more employees.
Although they have now changed the rules in terms of expiry of fixed-term contracts, haven't they? So it used to be included.
Yes.
As long as they expire on the date they were meant to expire.
That's right.
Is that right? They don't no longer need to be included.
That's right. They don't need to be included.
Yeah. The only other thing that I was just going to see if we could just fit back, just looking at that's fine on the definition. It's just where we're talking about proposing to dismiss, because that's a question that's often asked. I think it's again, I'm not going to go into all the case law, but I think the conclusions that are coming out is that it's before the actual decisions have been made, obviously, but it's something kind of between there and contemplation. So it's not as early as contemplating dismissals, but proposing is sort of in the middle.
Yeah.
Do you think that's fair?
Yeah,
to say?
you've got to have some kind of plan, but it can't be set in stone.
Absolutely.
So and it is quite. You will always find unions arguing that you've started this too late. You've started once you've gone beyond proposing to dismiss it. It's just one of the arguments always made. But you need to be doing it when your plans are in a formative stage.
Yeah.
So. Just before we move on to the next slide, if you're ready to move on, last point I'd make is this is always a really serious issue to get right, because the consequences of not following the collective consultation obligations are quite severe. Up to 90 days pay per employee affected, and the tribunals will award 90 days pay unless there is a very good reason not to. So it can get very expensive very quickly.
It can do. And I think the point to also note is just that if you think that you've got quite a number of redundancies coming up, but you want to stagger them into chunks, remember it's within a 90-day period, because it can be quite easy to get caught out, especially when you think about the wide definition of redundancy as well.
That's right. Yeah. So, and there are some different periods that apply in terms of depending upon precisely how many employees you're looking at dismissing during those periods. Just to help. Good. Then we will go on to individual consultation.
Okay. So individual consultation. So it obviously depends on the circumstances, but it obviously normally you would expect it to be giving the employee an opportunity to comment on the basis of selection, whether that's the selection criteria and their score, or the selection pool. Consulting with regards to ways to avoid the redundancy, of course, that's one of the key areas, and considering alternative employment. Timing and length of consultation, with individual consultation, there are no prescribed periods as opposed to collective consultation. But of course, the shorter the consultation, the more likely that the quality may be questioned. And when I mean, short, I think, anything, a week or less is very short. But of course, it is very much going to depend on circumstances. If you don't need a selection pool and you don't need the selection criteria because you've just got one role that's at risk of redundancy, then of course it's going to be a much shorter consultation period and process, that as opposed to one where you've got a number of employees in a pool with selection criteria and challenges and such forth. So no hard and fast rule, unfortunately.
Simple process, 2 meetings before confirming that decision. It can be done within a week. Again, it's one of these things you can never get right as an employer. Either you're going to have employees saying, well, that was too quick, it was a sham. Or you have employees saying, look, I just want to be told I'm redundant. And all sorts of things happen between them receiving that initial notification and confirming that decision. You know, grievances, complaints about the fact that they don't know what they're doing, office stress, etc. So I quite like to try to do it within about a week if possible, because I think it's, you know, if you've not got too many people to see, you can do that. And it keeps it fair. Keeps it fair for everyone.
We've just put on there right to be accompanied. There is no statutory right to be accompanied with redundancy meetings, but we just generally consider it to be good practice, especially at the dismissal or termination meeting. And that was all I was going to say on individual consultation, because it's we've talked about it a lot really. Collective consultation, again, I think, you know, collective consultation is pretty much probably a webinar in itself, but just to kind of go over some of the highlights and talk about a couple of the issues is, you know, who does the employer need to consult with? Well, we're either looking at a recognised trade union, or if not, representatives directly elected by affected employees. The only thing I'm going to say there is that there are rules about the election process that you need to follow, but I'm not going to recite them this morning. That's okay. Good. And we also need to consult with affected representatives of affected employees. So those are those employees affected by the proposed dismissals or by measures proposed to be taken in connection with the dismissals. Okay, so slightly wider there.
So effectively, if you're going to make a significant number redundant, and that's going to have an effect upon those left behind in terms of workloads, etc., then you need to be thinking about them and consulting.
Yeah, absolutely. There are provision of information. Again, there are rules in collective consultation as to what information must be provided. And with regards to the process of consultation and the subject matter of consultation, again, we kind of go back to the normal principles of, with a view of reaching agreement in terms of avoiding dismissal, reducing the number of employees that are going to be dismissed, and mitigating the consequences of dismissal.
Provision of information, really important. This is often it's referred to as a Section 188 letter, but there's actually certain prescribed information you must provide, and if you don't do it, then the consultation process has never actually commenced. So getting that Section 188 letter clear is really important. And of course, Form HR1 needs to go off to the Insolvency Service. Even if you're not in financial difficulties and you're making redundancies for other reason, you need to be submitting an HR1 form. Failure to do so is a criminal offence.
I did just put the question on there, when does it need to begin? And actually, you know, again, don't forget, you know, principles to consult in good time. You know, is the minimum period set out in legislation long enough? Well, actually, in reality, it most probably is. But I just thought I'd put that on there just to remind us of our general consultation obligations.
Maximum period 45 days now, where you're proposing to dismiss more than 100 employees at one establishment. Other thing just to bear in mind is how you interleave collective and individual consultation.
Yes, it is. And
it's there.
It's there. Sorry. It is. No, it's fine. But it's there just to flag it to you, and so that you now have, you know, on the slides, you know, 20 to 99 employees, you've got 30 days before first dismissal, and then obviously 100 or more, you've got 45 days. Notify Secretary of State if it says, and of course, if we do breach the informal consult duty, then obviously there's the award of protective award of 90 days pay in respect of each employee. So depending on the number of employees and the pay, could be very, very costly indeed.
One of the questions we're often asked is whether you can serve notice before either the 30 or the 45 days is up.
Yes, of course.
It's when the dismissal takes effect. So yes, absolutely, you can serve notice. Have to be careful though. The sooner into that process you serve notice, the more likely it is that the reps or the union will say there's a sham because you haven't given it long enough.
Making their voices heard, I would have thought.
Yes, exactly. But certainly you can give notice before you need to.
So that's consultation. So now on to selection.
On to selection. So selection is all about how you select which employees should be redundant. Now, it's one of the main battlegrounds we find in a redundancy process, particularly where you have more than a handful of staff being made redundant. And effectively, the way to look at it is that you create this pool of employees who are potentially redundant, and then you need to select based upon objective selection criteria from that pool. We put there, or is the employee self-selecting? Often you will be in a situation where actually you can say, well, no, the role we no longer need, the role that is redundant, is only occupied by one person or by a group of people, and that's one we're effectively deleting from the business. If it's self-selecting, then my view is you don't need to go through consultation around a pool for selection, or even identifying a pool or selection criteria. You can say, well, that's the role we're losing, therefore we're not going to go further in terms of selection. You can get pushback from employees in that situation, because one of the things they know, one of the things that ACAS will tell them is selection is a fundamental tenet of a redundancy exercise, that you can avoid that particular step. But if you are in a situation where you are reducing the number of employees doing a particular role from, say, 20 to 10, then you're going to need to look at your selection criteria, and it becomes a key part of ensuring that you've got a fair redundancy process. So you've got to identify your pool. What type of work is ceasing or diminishing? What type of work are those employees doing within that pool? Is it similar? What about other locations? If you've, say, got a finance team spread across 4 functions, you need to reduce the number of finance administration staff across those offices. How are you looking at doing that? You will find that employees are looking at whether or not their jobs are interchangeable with others. What are they actually doing? What are they being required to do? For example, if you've got a group of administrators and you need to reduce administrators in one area, should you be looking at putting all administrators across the business into the pool and then selecting, even if it's going to mean some reorganisation for those that do remain? We then need to look at the effect that collective consultation is going to have on selection, and the extent to which you're going to try to agree that pool with the union or employee representatives. And certainly one of the things I mentioned in the Section 188 letter, one of the things you have to do in that letter is identify the group or groups of employees who are potentially redundant, so that they can start to have that dialogue with you. So coming up with a pool is something which you need to give early consideration to. What can go wrong? Well, one of the big issues is interchangeability of skills. If you've got people moving around a lot, if you have people being trained and developed and moved on, etc., if you've got lots of very similar roles, then actually trying to identify the pool can be quite difficult. My advice, however, is I think it's you as the employer who is ultimately responsible for that pool. We go back to the test, which is whether or not you've acted reasonably in the circumstances, not whether the tribunal agrees with you. So ultimately, you're the one who is going to define it. We talked a bit about different sites and how you might do that, because of course, if you are looking at reducing numbers at different sites, that you can say, well, we should put everyone in those different sites in the pool, but at the same time, you might think, well, actually, what's the point of that? Because one site's in Ipswich, one site's in Norwich, one site's in Cambridge, and we're never going to get the employees from Norwich to go to Cambridge, or from Cambridge to Ipswich, or whatever. So again, that can give some rise to some issues. There are some commercial issues about having too wide a pool. The biggest one I always find is, as soon as you're doing that, then you've got everybody thinking about their futures rather than about getting on with the job. And so if you have a very wide pool, if you're going to a group of 50, 60 employees and saying we're making redundancies, there are going to be 5 of you going, and we're going to be selecting from that pool, you're not going to be getting much work done from those 50 employees for some time. And also, actually, the long-term consequences can be, lack of loyalty perceived by the employer to the employees can have an effect as well. So we have to be a bit careful with that. Finally, bumping. Do you want to explain that?
No, you can explain bumping. It's my least favourite topic in redundancy.
It is legitimate to bump in a redundancy situation. The times when you do it most often are where you've got some long-serving employees, or some employees with some particular skills you might want to keep, but they're the ones who are identified in the role. So bumping happens because you have identified a particular role that you're going to remove from the organisation, but you want to keep the individuals. Sorry, let me start that again. I've got all confused about bumping now. So I'm going to start again with bumping.
I told you, I don't like it.
You might decide, let's forget that earlier example, let's go for this example, right? You've decided that your labour costs are too high and you need to take, you know, X amounts of pounds of your labour costs. The way you can do that is by deleting one particular role, but you want to keep the employees who are currently occupying those particular roles. So you may decide that you're going to shift employees around, make some employees who are, do you know what, I'm sorry, I've completely forgot about what we're doing.
Tell you what, I think when we send out the webinar,
yeah,
shall we do a little explanation on bumping to accompany it?
Yeah, we'll do an explanation on bumping. Or we'll
which
cut
might
that
be
bit.
easier.
Or we'll cut that bit completely. So sorry about that. We'll do a separate selection on bumping. It's because you said it was really complicated, and all of a sudden I thought, gosh, it is, and I've forgotten all about it. So we'll move on. What else do we need to know about selection criteria? Tribunals really focus on them. They need to make sure, they will look very carefully about what criteria have you chosen. They will also make sure that if you have chosen them, then you have put the right employees, you have scored them correctly. So it is a major battleground in terms of redundancy, redundancy exercises. Try to get them objective. If you're using appraisals and you're using appraisal scores, then you can do so, but you've got to make sure that your appraisal process is up to scratch if you're doing that, because they're very easy to dispute. But so focus on skills, qualifications, aptitude, because they can all be measured to a certain degree objectively. Look at standards of work and performance if it can be objectively measured. Look at things such as attendance records, but obviously take out of those anything related to a disability, anything relating to maternity.
Yeah.
And also you can use things such as disciplinary records, punctuality records, etc. Yeah. But again, only live warnings. You don't want to be using those. Effectively, what you really need to do, and what works best, is if you can build up a matrix of 5, 6, 7 criteria, score each employees on those matrices, and that will give you a good rounded approach and will give you a certain degree of protection from challenge, because a tribunal which sees that kind of approach is not going to want to go through and individually decide whether or not your scoring has been right for each employee on that. So more objective, the more selection criteria you can build in, the better. Yeah, once you've got your selection criteria, you've got to make sure you apply it fairly. It is best practice to consult with all employees on the selection criteria you're going to use at an early stage, really. That, however, can lengthen the selection process, the redundancy consultation process as a whole, but best practice certainly is to say, we've identified there's a redundancy situation, we've identified there's a pool, you're in the pool, these are the selection criteria we are proposing to apply. I will often advise employers to skip that stage, but ideally, Council of Perfection would say you consult on it. Do be prepared to consult with employers as to how they've scored. You're going to have to share those. There will be dispute. There will be issues about that, because many employers will say, "Well, how very dare you? You know, you've scored me as only a 2 for the quality of my work, but look at my appraisal, so fantastic." The thing to remember is you're scoring employees for a particular purpose, which is a redundancy exercise. All these employees are good performers. They're not going because of performance issues. They're going because you need to restructure the workforce. So it can lead to dispute with employees which you haven't had before. Ladbrokes got themselves into a bit of trouble, I think, over this. What was that?
Yeah, well, somehow their proposed redundancy exercise was leaked. I'm not quite sure how, but these things happen. And they had a selection criteria set out, and actually one of the criteria was their employees and their ability to turn potential customers onto their online betting, which obviously is not really ideal in terms of, you know, gambling awareness and that sort of thing. So they've come out a bit of criticism criticism. The only other thing I want to say about selection criteria is that I had a case back in the day where we went to tribunal and we lost on redundancy. We lost for unfair dismissal. It was a redundancy exercise, and I think where we fell down was due to consultation. It wasn't proper consultation, but actually where the selection process rescued us, because we had the claimant in the witness box. It's not witness box, I'm exaggerating it, but at the table. Yeah, chair table in a little room. And through the evidence that she gave, she confirmed that actually the scores that she received was fair, and that actually and therefore Polti came in. So actually she would have been made redundant anyway, in respect of the consultation. So that's another reason why actually, if you have a really good concrete selection criteria and you apply it objectively and you've thought about your selection pool, it is really key. So,
no, it's important stuff. As is alternative employment.
As is alternative employment. I think the first thing to point is the first bullet point on the slide, that there's no obligation for an employer to actually find the suitable alternative employment. However, we need to search for it. And if we fail to search for it, then this may result in unfair redundancy. If we do manage to find and we offer suitable alternative employment, it needs to be done before the previous employment contract ends. And I put in there just to remember to widen the search to group companies or associated companies, because sometimes that's forgotten. And I've also put a note in there to remember those employees who perhaps are on sick leave or on maternity leave. And with the maternity leave, it kind of goes a little bit to, well, it does go to alternative employment actually, but the government plans to extend the protection for those on maternity leave at the moment. So those on maternity leave, obviously, they're kind of higher up in the pecking order of being given alternative employment. And it's currently just for those that are actually on maternity leave, but it is they are currently consulting on extending it to from pregnancy through to maternity leave, through even to 6 months after they return to work after maternity leave. So that's not in law at the moment, but it's something to watch, because I think that really will change the landscape there, because I do know had a number of conversations over the years now. We'll just wait till she comes back in a month's time and then we'll start the process. Dare I say it, sometimes does happen, doesn't it? So that's kind of alternative employment in a snapshot. Suitable alternative employment. It is important. There is an important distinction between offering alternative employment and offering suitable alternative employment. Why? Well, mainly because for you employers, if an employee unreasonably refuses suitable alternative employment, then they forfeit their entitlement to statutory redundancy pay. So what is suitable? Well, what will tribunal look at? They'll look at the employee's skills, their experience, whether they meet the requirements of the job on offer, and then they'll look at the terms of the alternative job, the status, place of work, tasks to be performed, pay, hours, responsibilities, and how does that compare with the previous employment. Snapshot of what does the case law tell us? Well, case law tells us that a drop in status is most likely to deem the alternative role as unsuitable as opposed to suitable. For example, I think there's an example of a head teacher being offered like more of a teaching assistant role. Pay, of course, is obviously going to be a key consideration, but there's two ways of looking at it. The fact that the pay stays the same but status dropped isn't enough to make it suitable employment, and the flip side, of course, is that if the pay does drop significantly, then it won't be suitable employment. And tribunal might also look at the arrangement of working hours, for example, if there's some new shift patterns being introduced, loss of overtime, perhaps, and even an individual's kind of outside of work commitments as well become relevant when looking at suitability of employment. And of course, location, because I think there was one case that the judge said that commuting is not generally regarded as a joy, apparently. But what I want to end this slide with saying is that that is suitable alternative employment, okay? And there is a distinction between suitable alternative employment and alternative employment. But of course, all those things I've just listed could be a genuine offer of alternative employment to an employee to keep their job, especially.
And I think we're looking at the job market two ways, aren't we? It's relevant to two things. Alternative employment per se is relevant to that holy trinity. Are we fair? Are we reasonable? Have we considered alternatives? And I think the view there is, make sure if you're going through a redundancy process, get as many of those vacancies out as possible to the workforce. make sure that you are encouraging them to apply. You don't have to appoint, however. If
No.
they're not right for the job,
No.
then you do not have to appoint. You may get some scrutiny from the tribunal on that, but
Yeah.
it's your choice.
Yeah.
Whereas when we're looking at the suitability, that's when we start to look at the effect it has on redundancy.
Yes.
Redundancy pay, isn't it?
Yeah, absolutely. Trial periods. So when is alternative employment subject to a trial period? Well, we have a statutory test for that. So we look at the Employment Rights Act. And if the capacity in place in which the employee is employed and if the terms and conditions of the alternative employment are different, wholly or in part, from the employee's previous employment, then we have a trial period. It is a mandatory trial period. It's a statutory trial period that lasts for 4 weeks. When looking at this, all differences count unless they are trivial or insignificant. And we look at each individual employment term. We don't look at the whole package. So we don't look at what the previous contract looked like and what the new contract looks like as a whole. We look at each individual employment term. And even if the new terms may be more favourable than the old terms, then that's still a difference, resulting in a trial period. So moving on, the trial period. So what is the purpose of them? Well, essentially the purpose is for both the employer and the employee to assess the suitability of the terms of employment for the employee. As I said, it's for 4 weeks, and I probably won't emphasise this enough or maybe too much today, but it takes effect automatically. And I do know that sometimes this can be overlooked. It really can. And when does it start? Well, it starts when the previous contract ends. And the other point I wanted to make is when we say it lasts for 4 weeks, it's 4 consecutive weeks. So even if there's perhaps a shutdown, I know over Christmas in between, it doesn't matter. It's 4 consecutive calendar weeks. So if the employer only does 2 of it, tough. Okay. It is good practice, make sure that you tell the employee during the consultation period that if you're offering alternative employment, that it'll be subject to a trial period if it's going to be. And refusing to agree a trial period could render a redundancy dismissal potentially unfair. So that was those are the points I was going to make there. I'm then going to talk about completion of the trial period. And obviously, if it's successful, then the ending of the original contract seems not to have been a dismissal. For statutory redundancy pay purposes, of course, they're not made redundant. There's no statutory pay entitlement, and the employee just continues to work in the new role. If it's unsuccessful, then the employee is regarded as dismissed for statutory pay purposes at the date when the original contract ends. So termination during a trial period, if it's by the employee, then again, as I said, they're treated, so even if it's during the trial period rather than at the end, then they're treated statutory redundancy pay purposes being dismissed on the date when the original contract ended and for a redundancy reason. They're also treated as having refused that job offer. So again, think about, well, was it suitable alternative employment and potential impact on statutory redundancy pay. If the employer is terminating, we just have to double check why we're terminating. Are we terminating because actually we found that the role was unsuitable for the employee, or are we actually now terminating for a different reason due to misconduct? Because that's a different reason for the dismissal, and then the redundancy situation kind of falls away. So I was just going to make that point, just to be careful with trial periods there. Issues surrounding trial periods, the number of times I'm told 4 weeks just isn't enough. It's just not enough. It is actually quite a big change to be, asking them to step up into the role. It's just not enough. Well, the issue we have with statutory trial periods is that it's quite difficult actually to extend them, and we are only able to extend them longer for 4 weeks if the purpose is to retrain the employee for the alternative employment. If we want to do that, then the employer and the employee have to agree to extend the trial period, and that agreement must be in writing and finalised before the end of the trial period, and state the date on which the retraining will finish. The other point I wanted to make is that if the statutory conditions for extending the trial period aren't met, then the employee will lose their entitlement to statutory redundancy pay. But also, of course, from the employer's perspective, just be careful as what the reason for termination will be. So if we haven't properly followed the rules for extending the trial period and then we terminate, say, 2 months later, where are we in terms of what was the reason for redundancy because we haven't followed the rules?
Yeah.
So it's just an area that I think we just need to be aware of, and it is, it's a statutory rule, so we do have to be mindful of the rules. The other point I was going to make it with regards to extensions, there is no set period for how long you can extend for, but again, focus on the need, which is to retrain the employee. I put on there the question of what notice or notice pay is an employee entitled to in the event of a statutory trial period being unsuccessful. I can't actually answer that question definitively. It all really depends on how we communicate trial period and how we communicate the end of the contract previously. So, for example, you might say an employer says a redundancy situation, your employment's going to terminate by reason of redundancy. We're going to issue you notice, and then we have a trial period because we've found your alternative employment. But how are we communicating when and then they might say, well, if it doesn't work out, then your employment will terminate at the end of the trial period. Because there's a bit of, if but maybes in there, in terms of the trial period, actually, is that clear and unequivocal notice? Is that valid notice? And we talk about this on many different aspects, don't we? What usually happens is that an employer will just say, make it expressly clear that when offering the employment, if it's unsuccessful, then they'll be subject, then they'll receive the notice, or more likely the payment in lieu of notice at the end of it. But again, it's quite a tricky area. It's fine, but it's just thinking about it and making sure you get right so you don't become unstuck along the way.
It's one of those, it doesn't come up in every redundancy at all, does it?
No.
And often it's always struck me as one of those rather technical areas which is slightly old-fashioned and out of date, given the way the law has moved on. But at the same time, can be very important in particular cases. Which just brings us on to redundancy pay and eligibility for redundancy pay. We won't go into this in too much detail, but you've got to be an employee. You've got to have 2 years continuous service. You've got to have been dismissed from that employment by reason of redundancy. But remember what I said, there is this presumption of redundancy in certain cases. We won't go through the entitlements, but they're all there.
Yeah, although the only thing I was going to say is that it seems that the weekly pay is not going to increase in April this year.
Right, because it normally does, doesn't it? It normally goes up by RPI.
Yeah.
So that's an interesting one. But it has got to quite a high level in many respects, redundancy pay. So there are circumstances where an employee will lose their entitlement to redundancy. Now, Vanessa's already talked in detail about suitable alternative employment. An employee will not be entitled to their redundancy pay, the statutory redundancy pay, if they have unreasonably refused an offer of suitable employment. What do we mean by unreasonably refused? Well, what we mean is it's not just enough that they've said they don't want to accept an offer of suitable employment which is at the same status within their skills, on the same pay, etc. They've actually got the ability to say, well, the reason I'm not taking that is because, and it's the because that becomes important. Case on this I'm aware of involving I think it was a PC, a primary care trust around in Devon, who had an employee who had been, I think she was mainly field-based. There was a redundancy situation. They wanted to move her into a more static environment. She said that was not suitable alternative, or rather, she said that it was not reasonable for her to take that. Her refusal of it was reasonable. The PCT said otherwise. The PCT agreed. Sorry, the tribunal agreed with the employee. They said that they could see that it would affect her job satisfaction and also her career progression. And for those two reasons, they said it was not unreasonable for her to refuse that. So they will give a lot of scope to employees to refuse. These debates don't get to tribunal very often because you're not arguing about too much money, so they tend to get settled. The one time I see them come up is where the employer applies the same test for an enhanced redundancy scheme internally as a statutory scheme. And there you can be arguing over much bigger sums of money. My advice is always to make your enhanced schemes non-contractual, specifically, so you don't end up in that position. But that's easier said than done. Obviously, an employee will lose their entitlement to redundancy pay if they do not work for the whole of their notice period. So if you give them notice,
often happens. They find a new job halfway through.
Exactly. Terribly sorry, you're no longer required here, but we do want you to work the 3 months' notice. Halfway through that, the employee either gets bored or gets another job and wants to disappear. If they just go, they will lose their entitlement to notice, to redundancy pay. What they can do, however, is serve notice to say that they want to bring their notice period to an end. And unless the employer goes back with a counter notice to say that they must remain, then they can go and they will still be entitled to their redundancy. And that comes up occasionally, that kind of situation. Often, however, an employer will do a deal around notice and redundancy just to get them out quickly, and that's where you may use a settlement agreement to ease their move on. So finally, I think we just look at alternatives to redundancy. This is something you should really always take into account when you're looking at whether or not your dismissal is your redundancy exercise is reasonable. So it's actually good to look at it at an early stage, look at headcount, find ways of perhaps reducing that in other ways or freezing it in other ways. Look at whether you want to get more of the workforce to go part-time. You can look at temporary stoppages, unpaid leave, etc.
Check the contracts though, especially with layoffs.
Obviously check the contracts, If you're saying to employees, well, actually we haven't got any work for you now, so we're going to lay you off for 4 months, for 4 weeks. Again, happens when you're refurbing a lot. Then you can get yourself into some quite technical areas to do with whether or not there's layoff or short-time working there, and whether that entitles an employee to go with redundancy payments early. But it is always worth addressing these in your early planning stages, because a tribunal would ask about them. So that's all we wanted to say. I'm going to go away and practice what I know about bumping redundancy. I have now thought of an example, but I'm not going to go there because it could be disastrous again, and maybe we'll do a whole section on bumping redundancies. But if any of you have any questions on bumping, please do contact us. But thank you very much for listening.
Yes, thank you very much.
Hopefully that's been useful to you, both as a refresher or as an introduction, and as Vanessa said, use the slide back if that's useful to you in your training, or just to get a bit more insight.